Do I have to click got it? So yeah, that's fine.
L control for the second half, L control for the second half.
Good morning, everyone.
Good morning, Judge.
Morning.
Fritz, how are you, sir?
Pretty good. Yourself?
Fine. Okay, let's see, I believe we're on the record. Let me announce the case. This is Fritz versus Klein, case number 2020, CV 181. Let the record show that the petitioner, Frederick Fritz IV, appears in person, as does the attorney for the respondent, Laney Barnard, also appears. When I say in person, I mean in person on Zoom. What we have scheduled for today is a non-evidentiary hearing, which the court had set for today. Basically, let's see, the respondent has filed a motion to dismiss, and the court would like to consider our oral arguments on that, along with any other motions that we have, and the court will consider the records and the files in the case. So, Ms. Barnard, would you like to proceed?
Yes, Judge. So just briefly, as the court, Mr. Fritz, are aware, this case was remanded back from the Court of Appeals. I believe it originally went up on some issues surrounding administrative remedies and things of that nature. But the direction to the court and to the parties on remand was a direction that the court issue the writ, which of course the court did, and then consider the Jamerson factors and determine whether or not Mr. Fritz can establish the state has impaired his liberty interest without affording him due process. And so, Judge, I think, and again, relies on the Jamerson case and cases surrounding long-term restrictive housing, administrative housing. I would note as I went back and looked at some of those cases, long-term restrictive housing or segregation in some of those cases looked a lot different than it does in Mr. Fritz's case, and just typically corrections, how things look today. So a lot of discussion in those cases surrounded just isolation. They were housed, inmates were housed by themselves. There was no outside contact. And I think that's probably one of the conditions that those cases focus on as far as being atypical and a significant hardship. And so, again, Mr. Fritz and Department of Corrections, Kansas Department of Corrections, that's not what long-term administrative housing looks like today. But the court, and I think probably the impact of Mr. Fritz's case is if courts throughout the state follow it, is that whenever a resident of the Kansas Department of Corrections is in long-term restrictive housing and has been for some amount of time, that a court is going to have, there's no summary dismissals, that the court is going to have to go in and look at the specific conditions of whoever that inmate or resident is, what their conditions are, do a specific inquiry as to what their conditions are. And so Judge, in my motion to dismiss, I think we all probably know more about Mr. Fritz's life in the El Dorado Correctional Facility than we ever probably wanted to know, but I think it's necessary to dictate and show the court and show the Court of Appeals or whatever court that may look at this later on what those conditions are. And so, Judge, I'm not going to go through the numerous exhibits that were attached to that motion to dismiss, but you can see that Mr. Fritz, you have photos of his cell. He's got a window, he's got a phone on the wall, he's got a remote control TV, he's got earphones, he's got a fan, he's got books, he's got all sorts of things in his cooking equipment. He has, unlike some of the cases in the string of case law, he's got or at the point that the motion was filed, he had a cellmate of his choosing. He got input on who that person is. So he's, this isn't a situation where he's isolated from human contact. Again, he has the phone on his wall. I think you have his phone records. He uses that phone. Each resident has their own tablet, similar to an iPad. Doesn't have obviously free access to all internet, but there's games on there. I think most people use them for messaging, movies, things like that. So he's got the tablet, which he uses frequently. He has, he has romantic relationships, women that he keeps in contact, friends and family he keeps in contact with. On those tablets, he is not allowed to have in-person visits, but he has video visitation. He's got access to canteen. He exercises in his cell. I think that's getting ready. If it hasn't happened already, I know there's a change in restrictive housing where they're going to get more yard time. So Mr. Fritz could probably explain better than I can if that's happened yet. But the conditions in which he is residing, I think are different than the circumstances of some of the cases that we see in this string of case history. But again, as the Court of Appeals directed, when there's this long-term administrative housing, restrictive housing, the court's required to go in and look at those things. And so that's what I've provided to the court is, exactly what Mr. Fritz's lifestyle looks like. And I think when you look at that, and again, his TV, there's the cable channels, I can't remember, maybe 40 channels, I can't remember, it's in the motion, but number of free television channels that are provided by the department at no cost to Mr. Fritz. When you go in and look at those conditions and Mr. Fritz's living conditions, I don't believe by any stretch of the imagination that those conditions are atypical or constitute significant hardship in relation to the ordinary conditions of confinement. I think Mr. Fritz said in a text to a friend or family member something about, the only difference between restrictive housing and general population is the in-person visits. And I think he has some explanation of what that meant. I'll let him certainly explain that for the court, but I think that's actually accurate. Judge, again, I think the court has been provided. I know the court had questions about, do we need an evidentiary hearing, witnesses, those sorts of things. I think the information regarding Mr. Fritz's living conditions and the exhibits, they're mainly business records. So I don't know that there would be a need for a evidentiary hearing. I know there's some mention of a evidentiary hearing in the Court of Appeals opinion when it's referencing Jamerson, and I think that's in there just because there was no other evidence. The record was scarce, I think is the wording they use. There wasn't evidence in the record of what those conditions look like, which is different than here. When the court has in front of it the department's motion to dismiss and the numerous exhibits outlining Mr. Fritz's conditions.
Ms. Barnard,
Yes, Judge.
let's discuss a little bit his opportunities to get out of long-term segregation. I understand that there's some type of a step-down program. There may have been some efforts to transfer him to another facility, even out of state. I know that there has to be an administrative hearing, I think at least once a month. Let's talk a little bit about that. Could you discuss that a little bit?
Sure, Judge. As outlined in the motion to dismiss, Mr. Fritz went through the process to be interstate compacted. And so there's a process. Not everybody's able to do that. There's a process. It has various approval levels that have to be met before somebody is eligible to have those interstate compact opportunities explored. And so Mr. Fritz did all that. He was approved. In his situation, and there have been a number of states that have been contacted, both formally and informally, regarding compacting, taking Mr. Fritz. Unfortunately, they get to decide whether or not they want to take a Kansas DOC resident. And in Mr. Fritz's case, when they get into his history and see the STG affiliations and some of his violent history, they all decline. And so I know there's been 8 formal submissions. 7 of those, at the time I filed the motion, had formally declined, and I think there was 1 pending. I'm assuming I would have heard about some sort of decision on that. So my guess would that last submission would still be outstanding. In addition to those 8 formal submissions, there have been just informal conversations with other states who, again, for the same reasons, have declined placement of Mr. Fritz. And so, Judge, you mentioned the step-down program. My understanding, and I'm certainly not an expert on the step-down program, but my understanding is that because Mr. Fritz is on that compact list and those efforts are being explored for Mr. Fritz, it precludes him from the step-down program, is my understanding. And again, not an expert, but that's my general understanding. And so that's why Mr. Fritz is not involved in the step-down program. And I think you've heard about the step-down program in other cases. You know, there are conditions. The person has to want to work that program, and there's a contract and all sorts of things like that. But I think that's the issue with Mr. Fritz and the step-down program is if you go this direction to be considered for interstate compact, then you're on this track versus if you're working the step-down program. So I think that's his issue with not being involved in the step-down program at the initial problem, I'll say.
I know in some of Mr. Fritz's pleadings, he's indicated that he believes that the monthly administrative hearing process is pretty much a sham, I think, to use his words. What do we know about that?
So
I know you had a couple of exhibits, maybe like July or August, his reports from then. Anyway, go ahead.
Yes, Judge. So he does have those 30-day reviews. I think he has an annual review. He also, I think they do a 6-month review too. And so there are professionals, DOC professionals, clinical staff, security staff, classification staff, and that panel, excuse me. So that panel conducts the restrictive housing reviews monthly, and there's, you know, you've seen the reports and the reviews. Sometimes residents attend, sometimes they don't attend. But you know, it's a review whether or not placement should continue in restrictive housing. And they consider a number of things, which I can't list off to you, unfortunately. I don't know if we have I think that I admitted the IMPP, unrestricted housing, but they go through that process monthly. The report's generated. And that's required by policy, and it's done every month for Mr. Fritz and any other individuals in restricted housing.
Another thing that he mentioned, and I've seen it coming up in a couple of other cases, is these suicide blankets. Now, I don't believe that he put that in his original petition, but I believe in his response to your motion,
Yes, Judge. So I would say maybe this.
What's up with that? Do you know?
Sure. So this spring, they're called sleep systems, and they were implemented by the department in response to residents using their sheets to
Hang themselves.
suicide. And so the sleep systems, it's like a sleeping bag, and certainly Mr. Fritz can explain as well. It's like a sleeping bag with Velcro along the bottom, and then one side, and there's a built-in pillow. So restrictive housing and residents' bedding was replaced with those sleep system. They're laundered the same amount of times, all those sorts of things. I know there have been some complaints about those. Residents don't like those, but they're done. It's not punitive. It's a safety measure implemented by the state, replacing that bedding. And so I think it's gone, as you can imagine, if things go out in stages in the department. And so restrictive housing at El Dorado, I think, was the first group to get those sleep systems. So it's like a sleeping bag with a built-in pillow with Velcro around the bottom and one side. I think that Mr. Fritz, I don't know that the one side is Velcroed. I think it's like opens up and then it closes. And so you can either sleep with it sealed or sleep with it open.
So if it's kind of cold and he wants to sit at his desk with like a blanket, he's not able to do that. Is that correct?
That's my understanding. I'm trying to take a look at his photos and see if those were. Yeah, so you can see the sleep system is in his photos.
What exhibit is that? Can you tell me?
So exhibit S is his photos.
F as in
I'm sorry, S, Sam.
S as in Sam.
You can see the material of the sleep system, and there's no blankets. He has, other clothing he could put on, those sorts of things. There does actually appear to be a sheet or something in one of the photos folded up.
Okay. Is this system wide now? Has KDOC established that at all everywhere now?
Judge, that's my understanding. It's that is to be implemented throughout DOC. I can't tell you exactly how many facilities, or I think El Dorado was the first, and restrictive housing was the first at El Dorado.
But
yes.
only for restricted housing. What about general population?
Yeah, my understanding that if it's not in place now for general population, that it's coming. And my guess would be that those are in place for GP as well, general population as well, at the El Dorado Correctional Facility.
Okay. One other thing I want to ask about, and that is, I understand that recently there's been a policy about no magazines, newspapers, periodicals in restricted housing.
Yes, Judge. And I think there's you issued a writ regarding that, and I've recently been looking into that, and I am hopeful that frankly didn't make much sense to me. And so as I'm exploring the basis for that, I'll just say that certainly I don't have the authority to make policy changes or anything like that. But it's definitely part of a discussion. But yes, that is accurate. My understanding is that there was when the property IMPP was updated this spring, the restrictive housing residents, basically whatever books and magazines, those sorts of things that they had were grandfathered in, but that they couldn't buy any more books or magazine subscriptions and those sorts of things. So yes, Judge, I am aware of your writ. I'm aware of the issue. And at this point, I can just say that I'm exploring that and share the court's concerns.
Well, and I am disturbed about that somewhat. I mean, I can understand Playboy and those kind of magazines. That's one thing, but
sure, I agree.
If a guy wants to look at Time magazine or
no, I agree. And again, when you're in restrictive housing and you've got a TV and you've got a tablet and you've got all these other things, it seems a little odd that suddenly a magazine is an issue. But yes, Judge, I share your concerns, and there are ongoing conversations regarding that part of the property policy.
okay. Well, I'm glad to hear that. One other thing before I turn to Mr. Fritz, and that's on the tablets. And as I understand it, you're not out on the internet, but yet you're able to message. And how does that work?
Judge, there's a provider, and I think there's and again, Mr. Fritz can probably tell you exactly about the cost. There's a small fee, a few cents, something like that, for each message that's sent or received. And it's a service provider, and they contract with DOC, and individuals, residents have an account with them, and they have their own individual tablet 24 hours a day. They used to share them, but now each resident has their own tablet, and so they can, if they had enough money on their account, they could message all day long. And Mr. Fritz certainly is an active tablet user. Also, facility messages, things like that, are sent out to residents on those tablets as well, just as part of communication and updating residents as to things that are going on in the facility or department-wide.
So it's kind of a private messaging service, something
Sure.
like that.
Yeah.
So if he wants to message his girlfriend, and I've seen some of those messages that you put in the exhibits, that goes through that service rather than out on the internet. And is she able to respond?
Right. And there's a review process. I think there are probably like a list of words and things like that that are censored. And so, if you say, I'm going to kill somebody, I think there's some sort of block on those, and then those are independently reviewed. So it's not a free-for-all by any means, but certainly
Okay.
Pretty open conversation, but for security issues, things like that.
Okay. All right. Let's see. Okay, Mr. Fritz.
Yeah, I'll start with the segregation reviews. These segregation reviews are everything but meaningful. They are in fact a sham, like I worded in my response, and I believe in my original petition.
And
when I go to
why do you say that, Mr. Fritz?
Well, when I go to seg review, the person in charge of deciding whether or not to retain or release me is not even in seg review. It's a unit team staff member, usually more than one, security staff member, and a behavioral health staff member. And I went to seg review last week, and the unit teams could not even decisively say why exactly I'm in segregation. They have no facts at their disposal to be able to make a decision. And when I press them about it, I'm told that it's not up to them. And according to the Sandin standard of a meaningful review, the people in charge of making those decisions are supposed to be in there. I believe it's Toussaint v. McCarthy. One second here. Yeah, Toussaint v. McCarthy, the court ruled that the prisoner must be allowed to present his views to the official in charge with deciding whether to transfer him to administrative segregation. And in 3 years, I've not had a single disciplinary report at all. I've had no disciplinary reports for violence or weapons since coming to segregation. And because of that, the K.S.A cannot show a subsisting reason to keep me in segregation. If I direct the court's attention to Kelly v. Brewer, and Circuit Court Judge Henley stated that reason or reasons for segregation must not only be valid at the outset, but must continue to subsist during the period of segregation, because conditions in prison change as they do everywhere else. And a reason for administrative segregation of an inmate that is valid today may not necessarily be valid 6 months or a year in the future. These placement facts are not being reviewed properly. They're not being reviewed at all. They have a policy of lock them up and throw away the key with me.
Do you have the cite on that Toussaint case and that Brewer case? Or
the Brewer
maybe-
is
maybe
Kelly.
Go ahead.
Sorry.
Yeah, go ahead.
Kelly v. Brewer 525 F2D 394.
Okay.
The Toussaint case, Toussaint v. McCarthy, is 926 F2D 800 803.
800 to 803. Okay.
Yes.
Okay. Thank you.
The interstate compact was not my idea. I did not do anything to make that happen. I didn't request it. It was laid on me when I was waiting to go to that step down program. Now, I was in Lansing in segregation for about a year and a half. And when I got transferred back to El Dorado, after being told, I might add, that I was going to be let out of segregation in Lansing, the seg review sheet from July of 2022, that's part of the respondents' exhibits. I believe it's Exhibit V, if I'm not mistaken. It said specifically that they recommend my release to population. And at the top of the page on the right-hand side, it said, as soon as possible. But when I got instead of that happening there, I got transferred back here to El Dorado and was told initially that I was waiting to go to the step down program. About 4 months into waiting, I inquired about how long I would have to wait for, and I was told that I was never approved and that I was going to go out of state because the state of Kansas doesn't want me on their yards anymore. The idea that I would forego getting out of segregation in order to sit and wait on a transfer that may or may not happen, that I could spend years waiting on, is just ridiculous. I've been in segregation now for 6.5 years. Again, I'm not a troublemaker. I don't sit down here and cause problems. The step down program, I was told, was going to be my way out of segregation. And then they pulled the rug out from underneath me. I didn't get any trouble. I didn't have any disciplinary reports. The simple fact is they told me that they don't want me. And it's not because of my behavior, it's because of a policy of predictive criteria. If I could direct the court's attention to Koch v. Lewis, I've cited it in my response. It says that there was a study done sponsored by the U.S. Department of Justice and the National Institute on Segregation, or on Corrections, rather, in January of 1999. And it suggested that segregation should be based on actual behavior, because attempting to use predictive criteria based on subjective information has led to historically unsatisfactory and possibly indefensible results. The court went on to say that a liberty deprivation should be based on misconduct and not status, and the court should be wary of regulations that provide otherwise. The prevailing theory, I guess you could say, amongst the staff members at the higher level of the KDOC is that they won't let me out of segregation because of something that may or may not happen. They are using a subjective reasoning to try to predict my own behavior. And I could understand that if I was in segregation causing a lot of trouble. But like I said, I haven't had a DR for any type of violence or weapons in the entire time I've been in segregation. And no DRs at all for 3 years. The segregation reviews fall short of any type of meaningfulness. I don't always attend them because they're frustrating. They don't tell me anything. They do not give me an opportunity to try to get out of segregation. I do attend them here and there to try to get an update if there is one. And just this last week, while going to seg review, it's policy to pull inmates out and stand us in the shower stalls while we wait. And this will touch on the conditions of confinement. While I'm waiting in that shower stall for about an hour, which isn't unusual, I'm standing in stagnant water that's full of hair and urine and semen and other body fluids from the night before, or whoever was in the shower. I pardon the graphic nature of that explanation, but it is the truth. And I stood in there for an hour to come to seg review to be told that the staff members can't even decisively say exactly why I'm in the hole. They told me that they would get a copy of the long-term segregation report, but I wouldn't be allowed to have it, that they'd have to read it to me or tell me whatever is in it that I'm allowed to know. The issue is that if no staff member can come to a consensus as to why I'm still in segregation during these hearings that are supposed to be meaningful, no proper notice has been given and due process is non-existent. And again, the ineptitude there is on an institutional level, not just with El Dorado, but it shows that in Lansing Correctional Facility in July of 22, I was told I was going to get out of segregation, which of course is not the first time I've been led to believe that. And instead of releasing me, they sent me back here.
And I imagine the problem has to do with that Leavenworth criminal case that,
well,
but you say, but you're saying in spite of that, Lansing after that said they thought that you should go to general population.
Yes, sir. In fact, it was in March of 22 when those charges were dismissed with prejudice. And bear in mind that the KDOC did not use any disciplinary process or anything to address the issues that arose to create that case back in in 2019, where they said the alleged incident occurred. I didn't get anything on paper that said anything about me being housed in segregation for that until 2021, in which case it didn't give any facts surrounding the incident. It just talked about a detainer being lodged against me. But again, I had that case dismissed with prejudice. Once it was dismissed, the unit team staff in Lansing agreed that there was no reason to hold me in segregation. They were ready to let me out of segregation. Then the unit that I was living in closed down for staffing reasons, I believe, and I was shipped back here to El Dorado, at which point I was told that I would be going to the step-down program. I was told by a unit team, Jeremy Hepner, and I'll try to give you the verbatim. He said, "We're not going to mess with you this time. We are going to give you a path to get out of segregation, stay out of trouble, and we'll get you into the step-down program." And 4 months later, I saw the unit team who's in charge of that program, in charge of all segregation, I believe, named Lewis. And Lewis informed me that I was never approved and that I was being waiting to go out of state. The interstate compact is I know the respondent may not be familiar with the ins and outs of how it works inside of a prison. The respondent's attorney, but this is not something that I asked for. It's not something that is going to help me in the long run get out of segregation, because if it does happen, it takes a long time, and I'm going to probably have to go to another state and wait in segregation there. Kansas is very clear that
It's, you know, prisons can generally decide where they want to put people. It's not up to you. Another thing on that Leavenworth County case, and I understand that it was dismissed with prejudice, but a dismissal is not the same as an acquittal, for example.
I'm aware of that.
We need to keep that in mind too. So, okay, go ahead. I interrupted you there.
You're fine, Your Honor. The idea that I take a bit of offense at the idea that the interstate compact is an opportunity that's afforded me. This is a punishment, Your Honor. That's not the idea that I'm being told that I can't walk a yard in the state of Kansas is not something that I'm happy about, because I know what happens when guys sit down here for years on end waiting for these things to happen. And it's never fast. The respondent's attorneys suggest that a lot of the issue is my STG validation in history of violence. Well, there is some violence in my DR history. It's not anywhere near as extensive as the state might have you believe. And the only way to show that would be to have an expert on the stand that could actually bring up real life individuals who are actually or not in segregation, on general population yards, who can compare my violent history with theirs. The STG validation, there's a due process violation there. If that in any way is keeping me in segregation, Kansas does not provide for an ability to contest a security threat group validation. There is no hearing. There is no notice. It's just simply done at the upper levels of the investigation division, and they decide that this individual is a security threat group member, and then individuals in my situation have to live with the consequences of that. Now, there are no IMPPs or regulations that provide that the KDOC must put somebody with a STG validation like mine in segregation. There's plenty of individuals with the similar validation with violent histories twice as long as mine who are on general population yards. Again, this is kind of goes to my argument that the KDOC treats me differently than they do most other inmates. As for the conditions of confinement, there is the sleep systems were implemented to keep us from committing suicide. And from what I understand, they started in Hutchinson Correctional Facility, but the only people that were required to use those in segregation were inmates with a mental health level of 4 to 6. And I'm not exactly 100% sure on how somebody gets mental health level points, but if you don't have an active mental health issue or you don't take psychotropic medication, I believe you're a mental health level 0 or a level 1. And the only people in Hutchinson that had to use those were people who were level 4 to 6 in segregation. Now, the conditions of confinement in El Dorado, yes, I do have a television. I have a window in my cell. I do have a tablet that I use, and it's not free. There's nothing on there that's free, but I do use it. And all those things together is great, but I spend 24 hours a day in a concrete box or a concrete cage, or steel cage rather. And all that being said, the KDOC thought that it would be wise to put every inmate in restrictive housing on suicide prevention protocol And they didn't do that because conditions in segregation are conducive to good mental health. I'd like to direct the court's attention to a case McCleary v. Kelly. Says a plaintiff need not show that every inmate confined in secured housing suffers from mental illness as a result of such placement to demonstrate atypical hardship. For the purposes of Sandin, it will suffice if the risk of psychological harm is increased by placing an inmate in the SHU for prolonged periods of time. If such is the case, then the increased risk is simply another significant and atypical hardship that inmates confined to SHU face, which inmates in general population do not. I think that by the KDOC's implementation of these sleep systems, I believe it shows that they have a worry about people sitting in segregation for an extended period of time and what they might do to themselves. Now, myself, I've never had any issues with self-harm. I don't take any medication. I'm pretty well adjusted in my own head. But to say that locking somebody in a concrete box for upwards of 7 years doesn't weigh on them and cause more stress than somebody needs is completely contrary to the truth. I do exercise on a daily basis, and I do things like that to keep myself sane. Miss Barnard is correct in that they have given us an extra day of yard, but this is not. We're getting now the amount of yard time I believe that we're supposed to according to federal and state standards. When as before for years it wasn't. We still haven't gone outside in a couple of months. Yard time is in a cell identical to my own cell, only devoid of a toilet and devoid of any furniture. It's absolutely no different than the cell that I live in, with the exception of there's no desk and no beds and no toilet. When the respondent noted that I had a conversation with my girlfriend and said that that the only difference between segregation and population would be contact visits. That statement was taken completely out of context. I don't have access to the business records of the GTL messaging system, but the respondent does. And if you look at that entire conversation, and it's not in the exhibits, it's only piecemeal parts of those conversations. But the entire conversation revolved around how much of my girlfriend, or how much of me my girlfriend would be able to have access to. And she lives about 1,000 miles away. And I responded that right now, the only difference in that would be I'd be allowed to have contact visits. But that doesn't go to say that the only difference between segregation and population is contact visits, because if that was the only difference, it wouldn't be segregation very much at all. I've outlined several things that are different in my petition, or sorry, in my response to the state's motion to dismiss about how different segregation is from population. Namely these suicide prevention sleep systems. It's my understanding that people in population still have sheets and blankets. But I mean, I could be wrong. Of course, I haven't been out there the last I knew. And there's a great deal of financial exploitation on inmates in segregation as well. We can take the tablet as an example. Yes, I have access to the tablet, and every one of those messages costs 25 cents. And for a service that in the real world would be free, I understand that they're going to charge us something, but that's pretty steep. It's not inexpensive at all. All the games and movies that she talks about, those all cost money. And I believe if somebody's in segregation, especially as long as I have been, locked in a concrete box for 24 hours a day, 7 days a week, 365 days a year, and I have the ability to spend money on those things, I'm going to do that if it helps keep me sane. Sometimes it does, sometimes it doesn't. But the fact is that inmates in segregation don't have very many outlets, and it's nice to have those, but at the same time, there's a financial exploitation to it. I could also point out, and I didn't talk about this in my response. But the canteen provider for KDOC is Union Supply Group. And on their canteen, they don't decide what's allowed in segregation or what's not. That's the KDOC's doing. Union Supply Group offers 2 packages of Q-tips, cotton swabs for inmates to purchase. And one is a 40 count, one is a 300 count. Both of them cost $3.79 to purchase. And in segregation, we are not allowed to purchase the 300 count box, only the 40 count box. And I know this might seem very trivial to you, Your Honor, but little things in here add up like that. And I feel financially exploited because I'm in segregation. And the only way to use something like that would be to pay an exorbitant price when inmates in population don't have to do that.
What do inmates in general population have in terms of messaging and message pads like you have? Do they have better access to?
No. I believe now that everybody has tablets that are personally assigned to them, I believe we all have the same access to those things.
Okay.
I think that's correct, Judge.
Okay. Oh, one other thing before you
Yes.
go on. That McClary versus Kelly case,
Yes.
and you have it cited here in your brief,
Yes.
but I can't read it's something F second 195, and I can't read
It's
Could you
second B.
give me the full citation on that if you would, because I can't read it on your.
Okay, it says McClary v. Kelly 4F sub
Okay.
2D 195.
Okay, that's a 4.
Yeah, I
Okay.
apologize. My handwriting is
All right.
not the greatest.
All right. I see that now. Okay, thank you.
The conditions in segregation are obviously different. As I sit here right now, I'm in chains. I wouldn't have to be in chains if I was in population. I mean, I went over a lot of the differences in my response, but conditions aside, the prevailing issue here is the excessive and indefinite stay in segregation with no opportunity to get out. I haven't been in any trouble in years, and the KDOC still refuses to reassess my placement. I believe that they lean on the STG validation to do this. In fact, it was the #1 topic that the respondent used in their motion to dismiss. I believe it was item #1. And without an evidentiary hearing to get into exactly how I was validated, why I was validated, who validated me, and what evidence they used to do that, I think that falls short of any type of due process because they don't give us a hearing to have those. The KDOC has ignored requests for proper due process, adhering to the unconstitutional policy of levying unspecific allegations via vague seg reports, lack of meaningful segregation reviews, making it impossible to properly defend myself or contest any of these allegations at a proper review hearing. What's really disturbing is that because I'm not given an avenue out of segregation, and I'm being told for 6 years, I've been told, or 5.5 years, I've been told that I'm not getting out. That's been their policy. And then they'll give me a little bit of a hope, and then they will pull the rug out from underneath me. My prison sentence alone makes this all the more egregious. I am serving a life sentence. I would see a parole board in 2029, but even if I get paroled, I would be paroled to a consecutive term of 27.5 years. And the fact that I'm being left in segregation with no means of getting out, no possibility to work my way out, means that there's a real possibility of a lifelong stay in segregation. And whether I have a television and am able to use a phone or a tablet, or even have a cellmate who I may or may not get along with and be locked in a box for 24 hours a day, 7 days a week with him, that is going to wear on anybody. Being treated like an animal every day, being given food that's inadequate, and when I say something about it, I'm told to shut up and be mad. Being hustled from one cage to another, being made to stand in stagnant water with body fluids in them while I go to a review that is meaningless. These types of things weigh on an individual. And the prospect of a lifelong stay like this, I don't care what types of stimulation you have, without human-to-human contact and the ability to socialize, I would love to see my family in person. Seeing them on video visits is great, but that's no substitute for inhuman contact with the people you love. And the idea of being stuck in segregation for life is in and of itself atypical in the KDOC, because you have inmates on death row who are awaiting capital punishment, who get to program on a yard with each other and with other inmates, personal connections. They get to move about without being restrained outside of their cells. The Sandin standard of atypicality is in relation to the ordinary incidents of prison life, and the reference point for that is the prison that you're in, not a prison in Rhode Island, and not a prison in Texas, not a prison in Canada. The fact is that when it comes to the atypicality, or excuse me, the ordinary incidents of prison life here in the KDOC, I am being treated atypically across the board. Again, I'll refer you to the state's motion to dismiss. They made my STG validation their number one priority in that motion to dismiss. Well, there's no policy that says that a person validated as a security threat group member has to stay in segregation. And yet that's the respondent's number one reason for wanting to leave me in segregation. That combined with the conditions that they say are not bad. Well, I've been in worse conditions for sure. And it's nice to have stimulation like television and phone calls and the tablet. But being locked in a concrete box, even with all that, can really weigh on a human being. That's all I have for you right now, Your Honor.
All right, thank you, Mr. Fritz. If the court would undertake some actual evidence in this case, would you have what would be your request in that regard? You know what I'm talking about as far as actually having a witness come testify about certain things.
I would request a number of different unit team managers and unit team counselors be allowed to testify. That way I could cross-examine them and show the court exactly how out of touch the SEGRA board that I sit in front of is with the actual placement facts, and how out of control, or how much of a lack of control they have in actually deciding my fate in segregation. I would also request an EAI supervisor be able to be cross-examined and questioned to get to the bottom of my security threat group validation, because if it is going to hold me in segregation, there needs to be an actual reason, or excuse me, there needs to be an actual notice given. If it's going to affect my liberty, I have to have due process in it. And because it's affecting my liberty, according to the respondent, and I haven't had due process in it, I believe we can remedy that here today, and maybe it'll give KDOC the inclination to change policies when it comes to validating inmates as a security threat group member. I would also like to be able to call different mental health, behavioral health professionals who work in the KDOC so that they can give a industry specific, if you will, perspective of what happens to an individual when they're treated marginally in segregation, whether or not they have stimuli at their disposal. I would also like to be able to understand to what extent the KDOC has attempted to send me to a different state. I believe there's 32 states on the interstate compact list that Kansas has legislation and contracts with, and yet they've only contacted 8 of them. I believe Darcy Holthouse could testify to exactly what she has done and to what extent they're trying to get this done, because it's my fear that they're using this as a pretext to leave me in segregation longer. It's easy for them to just, for lack of a better explanation, just kind of sit on their hands and just leave me where I'm at because they're content with where I'm at. There's a case, Hewitt v. Helms. I don't have the entire citation here, but it's cited, I believe, in the McClary case. And the court ruled in that particular case that administrative segregation should not be used as a pretext for indefinite confinement of an inmate in seg. In fact, due process is not satisfied where the periodic reviews are a sham. Reviews must be meaningful and simply not perfunctory. When I went to seg review a week ago, the unit team manager and the unit team and the lieutenant that were in here could not decisively say why I was in seg, how long I would be in seg, or anything else. The only thing they could find was that, yeah, I was waiting on an interstate compact. I believe it would be extraordinarily valuable to the court's insight as well as to mine and the respondent to be able to see the people that work in this capacity on a witness stand being able to be cross-examined, and we can get to the bottom as to why these seg reviews are not meaningful, and maybe it would give somebody the ability to make them meaningful.
Judge, I just have one comment. I just want to make sure we don't lose track of the direction given by the Court of Appeals. It sounds like we're the focus, the direction from the Court of Appeals, district court to issue the writ, consider the Jameson factors, and determine whether Fritz can establish the state's impaired liberty interest without affording him due process. So that's the direction of the Court of Appeals, and I think we're widening that with talk of interstate compact and STD validation, all those sorts of things. So I just want to make sure that we stay focused on the direction of the Court of Appeals.
Your Honor, if I may,
Go ahead.
the due process is kind of a wide issue. The idea or the fact that there are no meaningful segregation reviews in and of itself is a violation of due process. They don't afford us a review every 30 days out of the kindness of their heart. They do it because they have to. And problem is here in KDOC, they just seem to go through the motions. It's perfunctory. And I believe an evidentiary hearing can illustrate that for the court. And I believe that that's really the only way to get to the bottom of it. And I understand that the court is not inclined to take my word for it or the respondent's word, that this is about the facts and getting to the bottom of them. And I don't see any other way to do that other than an evidentiary hearing.
Okay, thank you. Ms. Barnard, on your exhibits, help me find the most recent administrative segregation review. And can you tell me what exhibit number that is?
So it looks like the segregation reviews are exhibit F, or I'm sorry, exhibit V. And then,
Did you say B as in boy?
I'm sorry, V as in Victor.
Victor, okay.
And I think I put them in chronological order there. So it would be the last page of that exhibit V, and The last one noted on that sheet, that review sheet, is dated August 9th of 23. And it notes offender chose not to attend restrictive housing review board.
I think I would like to have the updated ones from October, November, and December.
Okay, sure.
I want to think about whether or not I want to have an evidentiary hearing, and if so, on what. But I would like to have the October, November, and December administrative reports.
Sure.
You could just submit them, and obviously copies to petitioner.
Of course, Judge.
And I would like to look at those, and then I want to take this under advisement and think about this a little bit. I'm concerned a little bit about this step down program versus interstate compact, and obviously and Mr. Fritz says, don't take my word for it, and that's fine. I think he understands that I wouldn't just take what he says as gospel. But that idea of putting somebody on interstate compact as opposed to step down is a little concerning to me.
Okay, and Judge, I sent an email. I haven't gotten a response, but I wonder, and really this is a question for Mr. Fritz. And again, I don't know if this is an option or not, but Mr. Fritz, if there were a situation where you could remove yourself from interstate compact to explore the step down program, would that be something that you're interested in or not?
Yes. Yeah,
Okay.
I was interested in that when I came here.
Okay. And so I will, again, I'm not the decision maker there. I don't get to make those decisions. But I will inquire about that possibility, and somebody will reach out to you if that's an option. So certainly.
Well, and I'm glad you said that. It's not my place to tell people to negotiate together, I don't think, or whatever. But if there's something that could be done along those lines, would certainly be appropriate. Okay, well, in the meantime, Ms. Barnard, if you would submit those to me, and I'm going to reflect on whether or not what I want to do as far as evidentiary hearing. So I'll either do that or issue an opinion.
Great. Thank you, Judge.
Okay, all right. And obviously, if I do want a hearing, we'll set a time, set that up. And in any event, I will issue an opinion on this as soon as I can after I get those additional exhibits.